On this morning's docket, that is case number 108586, State of Kansas v. Williams.
May it please the court, Stephen J. House on behalf of Kiera M. Williams, and I'm not requesting any rebuttal time. My first issue has to do with what in trial courts is known as a sympathy instruction. It's been called that for a long time. There's been a lot of rulings on this instruction. It is an objectionable instruction and has been withdrawn from the PIC instructions. In this case, it was given at the request of the state over defense objection. And the findings by the court in regards to this instruction were just that the specific circumstances of this case allowed it. Whereas the law, as states both in the PIC and in the case law, that it's only under very unusual factual circumstances should this instruction be given. And the court's rulings in the past as to why is because it tells the jury what not to do instead of instructing them what they should do. Also, it tends to take away from the jury part of their purview of what they're supposed to do in judging witnesses, credibility, and so. So we're, objections to the instruction. Now, it's not per se error.
What about the trial court's explanation? I mean, the trial court went out of its way to explain why he thought this was circumstances which warranted giving the instructions. And he even prefaced it by saying, I usually don't give this instruction, but in abundance of caution, I think there's language like that. He went to several places in the record, especially regarding your client's conduct and emotion in the trial, and thought this was an occasion that warranted giving the instruction. Given that, didn't he follow the PIC recommendation that you only give it in exceptional circumstances, gave the exceptional circumstances, and then gave the instruction?
Well, and I think you need very unusual circumstances, and I would say both one.
And what are the, when you say that, what are the unusual circumstances? When does should this instruction, and maybe you'd get some of us to agree, it should just be thrown out and never given, or what are those circumstances where it's warranted?
Well, where it's been allowed before, where it's way back when in '76, they allowed the jurors and the defendant and counsel to go to someone's home to take testimony from somebody who was dying of cancer and was in pain. That would be a very unusual circumstance. That what started with this. So, but just crying or showing emotion is not very unusual circumstances, and I've cited cases, both published and unpublished, that are added in there, where the rulings have always been that mere emotion or crying is not enough to show unusual circumstances and to overcome any prejudice of giving this instruction. So I think you need very unusual circumstances, and there wasn't a finding by the judge of any unusual. I mean, he said his specific words were specific circumstances.
What peg are you of our standard of review are you hanging this argument on?
What? I'm sorry.
What peg?
Peg?
Well, I mean, this is a jury instruction, so I'm assuming that we're going down Williams, which is it factually inappropriate, legally inappropriate, or abuse of discretion?
I would say that it was factually inappropriate because he didn't make the findings that are required of very unusual circumstances, which I think is required to give this instruction over an objection. And so that's my reasoning that this, it's been disapproved. It has to do only in specific circumstances, and it's generally with crying and emotion not given. There isn't any warrant for that instruction, and it prejudiced Ms. Williams' constitutional right to a fair trial and to have the jury make the determination.
You have a constitutional right to cry through the trial?
I would say yes, you do. I mean, you have the right to show emotion. I mean, if it gets out of hand, you can have somebody removed from the courtroom. But obviously, it didn't occur in this case, or the person wasn't removed. I mean, you can have outburst. I would say showing emotion.
Well, if we agree that this was factually inappropriate because we didn't rise to the level of unusualness to warrant, what's our standard for reversibility? When do we reverse for
Well,
that error?
I would, the statement of the law, I believe you need some error, and I think there was error in this case. I mean, there's been saying that it's not per se, is what I'm using, but I'm saying on a factual basis of this case, based on the judge's findings, without making the resident findings, that it's wrong to allow it, and it's been shown by previous rulings that it's prejudicial, or it can be prejudicial to the person you're asking them not to show, sympathy or prejudice against, and it was asked for by the state in this case.
So why is this not harmless?
Well, it's not harmless because it affected other rulings, and the way defense counsel is allowed to argue to the jury. I mean, they kind of go hand in hand. It's kind of part of my brief here, but it's not harmless because it's been disapproved, and it's meant to take away from the jury part of their considerations that are part of their purview of what they're supposed to be doing.
Would you be making the same argument if, obviously you wouldn't if you requested it, but there would be circumstances, like you said, where the unusual circumstance where the state presents witnesses, like you said, the deathbed kind of viewing of a statement, or a victim is overwrought by what happened or the crime that was been perpetrated. And there's a finding made, yeah, that would be a circumstance. Are you just saying it's only when it disfavors your position, but it could be warranted in a situation where it's the state presenting a witness that might be that would lead to offering of this instruction?
Yes, the state, I mean, if I made a request for it because of one of the state's witnesses, say as I was a trial attorney in the case,
Right.
But there would still need to be a finding of unusual circumstances made on the record and the showing of what those unusual circumstances were, and it would have to arise, to the legal, using it as a legal definition of very unusual circumstances. And there's been cases where it's been raised by defense counsel. And so the cases I cite, that's what happened in
Right.
Holmes, and
I think typically that's, or maybe not typically,
Yeah.
that's not unusual anyway.
I would say more of the cases I found, defense counsel raised it than the state. So, but I think you need that, and it does prejudice, therefore it's not harmless when it takes a jury and you're instructing them to not consider certain evidence. So if there are any more questions on that, it kind of dovetail into my second issue. And with that issue, I would go to the recent opinion on the Hilt case, which is number 105057. I think it just came out a couple weeks ago. And, this has to do, obviously, with the additional request for instruction on the aid and abet instruction. The Supreme Court ruled, obviously, that it's not reversible error to not give that additional language. But it should be given if, it's appropriate. And this case, I submit, is exactly on line that it was appropriate. This was an aiding and abetting case. And get the right to do that under the Williams decision, 277 Kansas 338, where the trial court must instruct on the law as it relates to defense theories. And a request was made for the court to instruct on the defense's theory that mere presence is not enough, and it was denied by the court. And I think if you add that in conjunction with the sympathy and prejudice, it does show error, and harmful error in this case, as to what the jury may consider and how they consider testimony of the defense and the defense's defensive case. So I think if the law is that it should have been given, or the best interest, it must have shown, it says that it's not reversible error not to give it, but I would submit that it is error, and due to the circumstances on this case, in conjunction with giving the sympathy instruction, that it took certain elements that the jury was supposed to rule on out of consideration. And I looked at, if they allowed an objectionable instruction and then denied one that should be given, I think that's error, and legal error for not doing that. And it ties in, to my third issue, which I brought pursuant to the case of State v. Carter, 270 Kansas 426, where defense counsel basically told the jury that his client was involved, was morally and ethically wrong, and I submit to you that takes away a client's right to be represented and Sixth Amendment rights in this matter, in that...
Well, there's a distinction here as I see it. In Carter, he said, the counsel said, well, he's guilty of this, but he's not guilty of this. Here, counsel said, well, ethically and morally, this may be culpability, but legally it's not. And so counsel actually argued against, or argued for a not guilty verdict, as opposed to Carter says, convict him of this, but not of this. So how is that a guilt-based defense rather than a unlikable person defense?
Well, it's a guilt-based because part of the statement was she shouldn't have been involved. That's like saying she was involved in it. And so we didn't have the instruction on mere presence is not enough. And so then defense counsel says, okay, she was involved and she was morally and ethically wrong. And I'm sorry, but juries think the criminal law dovetails with morally and ethically wrong. That's what they think. And that's what they've been taught. That's why it's against the law. It's morally and ethically wrong.
Your last issue is cumulative error. I see you're getting close, and so I want to ask you something in that regard. If we think that simply that the no sympathy instruction was probably ill-advised, that that the court would have been well advised to have added the mere association language on aiding and abetting, but can we accumulate those when we haven't declared them to be error? In other words, two items that we don't approve, but we can't find that they were actually trial error, we can't accumulate those to make an error, can we?
Well, and I would say that they are error, and that the rulings have stated that giving them is not unreversible error. But I'm saying because they use the language, it's not unreversible error, it must be some kind of error. And then if you have to make that ruling that I think it is error. It shows that it is error on a factual basis. If
Yeah,
they
I
don't
guess
do
my
that.
question is, sometimes we say better practice, but it's not a
Yeah.
trial error. What I'm saying is, we can't accumulate, bad practices, to make a reversible error, can we? We
Well,
have to actually find 2 or more trial errors.
the Hilt case says you need to have 2 or more. I mean, an accumulative error. It does say that, but it did say that there wasn't more than 1 error. And I think it was referring to not giving the language as on the aiding and abetting in that. And so I would say if you have instruction that's been removed from PIC as an objectionable instruction, that's error to give it. And it was error to give the other instruction that we have cumulative error. And it's constitutional error, so it comes under the case of Chapman as opposed to just
Yeah.
statutory.
Explain, why is it constitutional error?
Well, right to a fair trial is given under both the Kansas and the U.S. Constitution.
Do we have
So
any
that's-
further questions of council? See you're out of time. Would you like 30 seconds to wrap up?
Well, I think my arguments go along, with the brief, that they are error, and it's been rulings, if it's maybe not unreversible error, but you can find that it's reversible error based on the circumstances, and it was wrongly given and combined. There was error taking certain, duties of the jury away from them by those instructions. And that's a constitutional error to a fair trial. And I think it should be remanded for a new trial. So, thank you.
Thank you, council.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. The first issue challenges the court's decision to issue the no sympathy instruction in this case, and as it was objected to below, this court looks at the instructions as a whole without isolating this particular one to determine whether they properly and fairly stated the law or whether the court could have reasonably been misled by that, or whether the jury could have reasonably been misled by that instruction. The purpose of jury instructions is to clarify for the jury its responsibility and to provide parameters for the jury on how it's to fulfill its role. This instruction was legally appropriate. The case law has directed that the instruction may be issued under very unusual circumstances. The district court here acknowledged that unusual circumstances are required before it can be issued, and noted that in this case there were specific factual circumstances that necessitated that it be issued, specifically that the defendant was having emotional breakdowns daily at trial, at counsel table, that she had emotional breakdowns during the point of her testimony, and that defense counsel highlighted her emotional state during direct examination. Now, I think what distinguishes this case from some of the others that have been cited is that we're talking about the defendant in this case. In the majority of cases, if not all the cases that have been cited to this court, we're talking about victims or witnesses, where it's typical that a victim of a violent crime or a witness who has observed a violent crime would have an emotional response to having to relive that. But in this situation, we have a defendant who's having emotional breakdowns daily in front of the jury. Cases are not decided on emotion. Cases are decided, verdicts are rendered based on the application of the law to the facts. This was an unusual situation. The jury's focus needs to be kept in the appropriate place. And for that reason, when we look at the instructions as a whole, the jury was properly and fairly instructed on the law as it applied to the defendant's case. Now, the defendant's assertion is that she was prejudiced because somehow, by issuing this instruction, the jury was no longer permitted to give the necessary weight and credit to her testimony. That instruction was given. The jury was still instructed it is your responsibility to give the necessary weight and credit to the witness's testimony as you deem appropriate. They weren't told you can't consider her demeanor. They weren't told you have to discount her testimony as a whole. They were simply instructed you may not decide this case based on sympathy alone. For that reason, the jury was, as a whole, properly instructed with respect to the defendant's case.
Counsel, the reason given was these emotional breakdowns or tearfulness. There wasn't any discussion at the time the decision was made to give this instruction about the history of the crimes and the involvement of this defendant as a crime victim herself?
I don't believe so.
Okay.
No.
Alrighty. Because it strikes me that that's an unusual circumstance as well.
Sure.
It might prompt the giving of the instruction, but that wasn't discussed.
And when you refer to her as a crime victim herself, can you clarify for me what it is?
Wasn't she the victim of the
No.
sexual assault? Oh, she
No,
was
that
a
was
different
Jalissa Bonner.
one. Okay. Sorry.
There was evidence brought out that when she returned from the apartment that morning, that she alleged that she had been sexually assaulted, and it was her tearfulness that prompted Kevin Brown to say to Jalissa, you better go investigate and see what's going wrong. And that's kind of what got the ball rolling. But as far as the gang incident that you're referring to, Justice Beyer, that was Jalissa Bonner.
Okay, thank you for clarifying.
But she did say that both Watley and Bolden had raped her when she had been over there overnight.
She said they had sexually assaulted her by fondling her breasts. There was no verification of that. There was no further investigation into that. That was just her tearful assertion, despite the fact that she had come home indicating nothing had happened with a typical demeanor, and it wasn't until after she had been home for quite a period of time that all of a sudden she lapses into this tearful episode now. But whether there's any validity to that, or there was no further investigation outside of what Kevin Brown allegedly had seen. The second issue challenges the aiding and abetting instruction as incomplete. And the supplemental language regarding mere association was requested below. So again, this court looks at the instructions as a whole to determine whether the jury was properly and fairly instructed. And that supplemental language is a proper statement of the law, but it is not necessarily, doesn't necessarily equate with reversible error. In this case, the jury was properly advised in accordance with the PIC instruction, and then during closing arguments, defense counsel made a concerted effort to make it abundantly clear to the jury that mere presence is not satisfactory or is not sufficient to establish guilt under an aiding and abetting theory. And accordingly, this is not a situation where the jury was left with an incomplete understanding of what is required under the theory of aiding and abetting. With respect to the last issue, the ineffective assistance.
Okay, let me see if I understand. Because defense counsel argued that mere association was not enough, that informed the jury that that was the law when they're told that statements of counsel are not evidence. And I have a little trouble saying that you can substitute defense counsel's arguments for the judge's statement of the law. Is where I'm getting at.
And I understand that, and there, and I'm aware that counsel statements aren't, don't carry the force and effect of that from the court. But with respect to the harmless error analysis that we find ourselves in under the necessary standard of review, I think you have to look at everything that was before the jury as a whole. They were properly instructed under PIC. This court has held that it doesn't equate with reversible error to not include that supplemental language, that it is in fact the better practice, but has not said its absence, as recently as 2 weeks ago, has not said that its absence is necessarily reversible error. So then that language that he argues should have been given was in fact presented to them. They had that entire body of information with respect to aiding and abetting before them, and for that reason, the state would say that we would survive the harmless error analysis under the standard of review. The third issue raises an ineffective assistance of counsel claim for the first time on appeal, and as we set forth in our brief, it would remain our position that this is not properly before the court for the first time on appeal. The alleged error or deficiency in counsel's representation necessarily would go to his trial strategy, and that would essentially be a factual matter that this court can't glean from the cold record itself, and therefore would deprive this court of the ability to filter it through the Strickland analysis. However, to the extent this court reaches a contrary conclusion, he is also not entitled to relief. He equates it with State versus Carter, and as Justice Johnson pointed out, in State versus Carter, it was a situation where defense counsel argued that he was in fact guilty of the shooting, but wanted to focus the jury instead on felony murder as opposed to premeditation. What we have in this case is more a situation where defense counsel is focusing on her innocence. And it was without question that she was present that evening in the vehicle, or that afternoon in the vehicle, by her own testimony. And as an effective advocate, counsel then attempts to mitigate that presence and says, yes, what she did was morally and ethically wrong in that she didn't intervene and do something in an attempt to stop this. But this was not a situation, as we found in Carter, where he's presenting a guilt-based defense on her behalf. In fact, he specifically says her presence does not equate with guilt for the crimes that are charged. She was morally and ethically wrong for not intervening to stop the crimes that she could see transpiring in front of her.
Do I recall correctly, did she help direct to the apartment, or was that just Bonner?
No, she assisted as well. Defendant argues on appeal before this court today that the chronic presumption is what should drive this analysis. And basically what we find under chronic is that it's very narrowly applied. And that's applied in situations where counsel has wholly failed to act as an advocate and where he has wholly failed to subject the prosecution's case to any sort of adversarial testing. And I think a fair reading of this case would demonstrate that this is not that type of case. For those reasons, the state would respectfully request that the defendant's convictions and the decisions of the district court be affirmed.
Do we have any questions of counsel? Thank you, counsel. Thank you both for the arguments this morning. Court will take this matter under advisement.